Good morning, everybody. Thank you so much for joining this morning. I'm Samar. I'm an immigration and global mobility partner at Spencer West. And today we're going to be talking about right to work. There's so much that's been going on in this space. So it's going to be a really interesting talk. So if you want to say something, please do not be shy. If you could put whatever you want to say into the chat, then I'll be able to kind of monitor that, and I'll address your questions as we go. I'm happy to do that as long as we have time. If we start running out of time, then I might ask you to contact me afterwards. Okay, so we have a lot of fun things to talk about today. Let's look at what those are. Sorry, I'm just having trouble controlling this. There we go. So I'll talk about the agenda, then I'll also talk about what we're not going to talk about today. So first, we'll talk about the consequences of illegal working. There have been some developments there, and I think that there are some consequences of which people aren't aware. So we'll have a look at that. Then I'm going to give a very brief overview of the basics of right to work checking. But the point of today is not a training session in how to conduct the actual checks. I do have a full suite of training sessions available. And so if you're interested in that, please let me know. Good afternoon, Dubai. Hadi has said from Dubai. Hi, Hadi, hope you're well. So anyway, we're not going to go through the basics in any detail, but I'll give a brief overview just so we're all on the same page. But what we're really talking about today is the changes. It's an update session. We're talking about changes. We're talking about quite exciting developments in case law and what they mean for you in terms of right to work checks. So we're going to talk about checking documents up until the 17th of May, exclusive, because there's a COVID-19 policy in place that applies until the 17th of May. And then we'll look at checking documents from the 17th of May. We'll talk about European Economic Area nationals. Obviously, there's a lot to talk about there. And then also discrimination, very interesting issues with right to work going on there as well. Okay, so as you can see, we have a lot to cover. So I'll get right into it. Thanks again for coming. So let's talk about the consequences of illegal working. And people often don't recognize the extent of activities that might be considered illegal working. Okay, so what is it? Employing somebody who's subject to immigration control. Now that's a key phrase and the crux of the Windrush scandal, because members of the Windrush generation had the right of abode and so weren't subject to immigration control, which was the root of a lot of their troubles. So it's somebody who's subject to immigration control and is not allowed to carry out the work in question. And that can mean a number of things. So they haven't been granted permission to enter or to remain in the UK. They just don't have any kind of visa or leave. That permission is invalid. That could be for a number of reasons. The permission no longer has effect. Now, that might be because it expired, but it might also be because it was curtailed. What does curtailed mean? It just means that the Home Office shortened their leave. So for example, a sponsored worker whose employer loses their sponsor license, the Home Office will write to that employee and tell them that their leave, their visa, it has a closer end date than it did before, basically. So their leave is curtailed, but they don't change the right to work documentation. So that's a situation where you might be seeing right to work documentation that fulfills the Home Office requirements, but actually the person doesn't have the right to work because their leave was curtailed. So that's the type of situation where it might be, where you might be saved by having done the checks correctly. We will talk about that a bit more later. So another possibility is that the type of leave that they have, the type of permission that they have, includes a restrictive condition. And again, this is quite loaded. So a sponsored worker is only authorized to work for a specific role. Okay, that's a specific job title. There's a specific salary level, specific job location. All of that's been reported to the Home Office. Okay, now, if the job strays from that, and particularly if the job duties change such that the role falls under a different standard occupational classification code, and that's the list of all the possible jobs, that's part of the immigration rules. They're organized to cover all the possible jobs somebody might have. And so when you sponsor someone, you match it to that job. If their job changes so that they match a different job to the one that the Home Office has on record, then that's actually illegal working too. So that's why it's so important for sponsors to keep up with their reporting duties. But this isn't a session about sponsorship. Let's talk a bit more about illegal working. So I'd like you guys to tell me what the consequences are of illegal working. And if I can get it to work, I will have a poll here. There, if you could please vote. I don't know if you can see that. All of the above. Some people are saying prison sentence, fines, sponsor license revocation. Interesting. Somebody's saying business closure. Okay. We've got about 75% of votes in. Does anybody else want to vote before I end the polling? All right, that's it then. I'm ending the polling and I'm going to share the results with you guys. Okay, I'm really proud of you. First of all, that somebody said business closure, because that is one, and that everybody identified all these other ones, but especially because the winning answer, the one that people voted for most, is the correct one, which is all of the above. So let's talk about that. So I'll just backtrack a little bit. We'll talk about the criminal offense and the criminal penalties, okay? Because a number of those consequences in the poll fall under the criminal offense and penalty framework. So it's a criminal offense to knowingly employ an illegal worker. Now, the way the liability works is to spread it really quite far. So anybody who has responsibility for the employment of the illegal worker is liable. Now, by extension, because they're part of the corporate body, by extension, the corporate body is liable, which means that any corporate officer, manager, or senior employee is individually liable. So the Home Office, well, the legislation extends liability from the person who actually knows through to the corporate body and then back down to officers and senior employees. So it's really quite broad. Now, what about the trick of just not checking so you don't know, so you won't be breaching, you won't be liable for a criminal offense? Well, that doesn't really work, because there's also this wording that's been in the legislation for a few years now about having reasonable cause to believe that that somebody's illegal working, and you're just as liable if that's the case. So if they find that you were kind of avoiding knowing based on the facts, then you're still liable. And so the criminal penalties are up to 5 years in prison, an unlimited fine now, and premises closure, so business closure. And as I said, there are some consequences that people don't know about, and this is one of them. So an immigration enforcement officer can come to the business premises and order it shut for up to 48 hours on the spot. Within those 48 hours, they have to go to a judge. The judge can shut the business down for up to a year. And in the Independent Chief Inspector of Borders and Immigration's report on illegal working, on immigration enforcement, in May 2019, it was published. The Chief Inspector's recommendation was for the Home Office to use this power more, okay? And I'll talk about this report a bit more as we go along, but basically the Chief Inspector found that immigration enforcement was not effective, that it wasn't sufficiently deterrent. And so it wants the Home Office to use penalties with more bite, and premises closure is obviously one. Now, obviously, the way the public might view the government closing of premises down in May 2019 is very different from how it is today. So there might be political issues with the increased use of that power today. But that was the government recommendation, and the government kind of hasn't had a chance to put the recommendations into effect because of COVID-19 and lockdown. We'll look at the data a little bit later, and you'll see it's quite old, unfortunately, but it's the best available. Okay, any questions before I move on? All right. So this is an example of an illegal working closure notice. So this is what the immigration enforcement officer would come and put on the physical premises when they shut it down for up to 48 hours. And you'll see this was for the much beloved East London restaurant Tayyab's, and they got a really hefty civil penalty fine for that. So that's just an example of what the closure notice looks like. Now, there are also effects on one's sponsor license. So bravo to anybody who noted that. So your sponsor license can be revoked. And in that case, all your sponsored migrants would have to find a new sponsor within 60 days or leave the UK. And you could be ineligible to apply for a sponsor license in future, or at least for a certain amount of time. Now, depending on the nature of your business, this might, basically have the effect of shutting down the business, because some are so dependent on migrant employees. Let's talk about civil penalties. So this is a framework that some of you, I think, will be more familiar with than the criminal framework. And that's apt because, the criminal framework is there, I believe, really mostly to scare people. And people get very worried about it. But it's, even after the chief inspector's recommendation, it's very little used. None of those powers are used very much. They really are reserved for the very worst cases of repeated offenses. So let's talk about civil penalties, which are in practice more meaningful. You can be, or the company can be fined up to £15,000 for a first breach, or up to £20,000 for a second breach of unknowingly employing an illegal worker. Okay, so knowledge is not required for the Home Office to fine you. The beauty of the right to work checks and the utility of them is that if there does turn out to be a case of illegal working and you can show that you did the checks properly according to the Home Office guidance, then you'll have a statutory excuse, or sometimes it's called a statutory defense from civil penalty, and you won't be liable. But what if you actually find out that they were working illegally? Well, then you won't benefit from the statutory excuse. Now, those figures that I cited at the top of the slide there, the 15,000 for the first breach and the 20,000 for the second breach, those are the default amounts that the Home Office starts off with when they're calculating the fine. And then there are these mitigating factors that will decrease the fine by £5,000. So maybe you already reported the suspected illegal working. Are you actively cooperating with the Home Office? And have you done so in the past? Do you have a system in place such that your right to work checking practices are generally robust? So any of those would mitigate the fine by £5,000. What if you did a partial check though? Okay, we'll see when we come to the brief overview of right to work checking that there are some quite strange particularities. What if you check somebody's right to work documentation, but the documentation that you have on file of the check, it's not exactly in line with the Home Office? Well, I've given you the answer there. That's technically, officially not a mitigating factor. It used to be, and even since it's been removed as a mitigating factor in practice, I've had some success in arguing that the partial check should be a mitigating factor and having a fine reduced or eradicated, but don't rely on it. There's no guarantee that they'll reduce it in those circumstances. So do try to follow the guidance for right to work checking exactly. So another consequence is naming and shaming. Congrats to everybody who chose that option. So you'll see here, these are the latest available data. This is illegal working civil penalties for which employers remained liable. So they ended up having to pay. They don't publish if they just issue you a fine and then it turns out you had a statutory excuse, etc. But if you remain liable and fine has to be paid, then they do publish. You'll see the name of your business, the trading name, and the amount. And these are the latest available. You'll see they have started to spread out the fines a bit. So one of the criticisms of immigration enforcement in that report that I mentioned by the Independent Chief Inspector of Borders and Immigration is that immigration enforcement was relying on tips from the public that related almost exclusively to ethnic restaurants, and then the immigration enforcement would go raid the restaurant. So it wasn't sufficiently deterrent for other businesses, basically, because other businesses were not being fined. That's a generalization. Have acted for businesses in other sectors that did receive fines and objected to those. But really almost entirely it was ethnic restaurants. So you'll see here they're starting to spread out. And the one that's most interesting to me is the one with the address at the Lansdowne Club. I don't know if any of you know the Lansdowne Club, but that is as fancy as it gets. So I'm interested to see that there. Previously, UCL received a huge fine for illegal working earlier than these stats though. And you'll see they're looking at hotels a bit more, a car wash. So previously it would have all been, Asia Kebab House type listings. So this is interesting. But the point really is that naming and shaming is a consequence. This information is published on the gov.uk website. That's where I got this snip from. So, and because of the Independent Chief Inspector of Borders and Immigration's recommendation, now that businesses are operating again, you might find that your sector is being scrutinized much more closely than before. So watch out. Right, I was going to do a brief overview of right to work check basics. Before I do that, does anybody have anything to say or any questions about the consequences of illegal working? No? Okie dokie. Oh, yes. Something in the chat. Do you think the technology sector could be targeted? Yes, I mean, really, if immigration enforcement is being savvy about it, the tech sector is one of the most heavily reliant on migrant workers. Now, there's a fine line to be walked there for the Home Office because they pay so much lip service to supporting the tech sector and particularly fintech. Um, so it could be it could be they could be shooting themselves in the foot a bit, but they don't seem to mind that very much, to be honest. So we'll see. I definitely would say it's much more of a possibility now than previously, given the independent chief inspector of borders and immigration's report. And that now is really the first time, because of the lockdowns, now is the first time that that would be tested, or maybe not even quite yet, but going forward. So it's really important to ensure that you have the right processes in place, regardless of your sector, more than ever. All right, so let's talk about right to work checks. I'll just go over some of the basics here. So we talked about the value, the utility of the right to work checks being this statutory excuse from civil penalty. Now, you'll only benefit from that if you have documentation, if you have a record of checking the person's right to work before they start work, okay? Excuse me. If you don't check before they start work, it doesn't matter how beautiful your right to work check records are, it's not going to afford you the statutory excuse, okay? So make sure you check before the person starts work. The processes could be part of a new joiner checklist. It's okay if you do it on the first day, so when the person actually shows up, as long as you can document that it's the first thing you did, okay? So, if you have a set itinerary or set documented policies about what you do when somebody turns up on the first day, and it shows that the first thing you do is check their documents, and that you send them home if they don't have the right documents, then that's okay. It's easier, obviously, less document heavy if you just do it before their start date. So there are a couple of different ways you can check documents. You can check them manually. So you're actually checking physical documents. There are the relevant documents are divided up into two groups, List A and List B. And then within List B, there are two further subgroups, Group 1 and Group 2. So List A documents are ones that show an indefinite right to live and work in the UK, and they don't need to be rechecked. So those are things like British passports. At the moment, European Economic Area national passports, a BRP card, a current BRP card, showing, sorry, that's biometric residence permit, showing indefinite leave to remain in the UK. Those would all be examples of List A documents. List B documents are ones that need to be rechecked, okay, in order to maintain the statutory excuse. So List B Group 1 documents need to be rechecked before they expire. So you'll need a good system for documenting the expiry dates. List B Group 2 documents you have to do a little bit more for, okay? That's the situation where you have to obtain what's called a positive verification notice, sometimes abbreviated to PVN, from the Home Office's employer checking service, okay? And those will need to be rechecked within 6 months of the PVN. Record the date of the check. That, if you're doing manual checks, that has to either be done on the photocopy or in a spreadsheet. So, this person's name, and then I'll show you the wording that you have to use about the date. So those are manual checks. Then there are also electronic checks. Now, electronic checks are really nifty. Basically, what you do is you access the electronic immigration status of the individual to verify their right to work. So that will show the date of expiry of permission, if there is one. Maybe they have indefinite leave to remain. but it will show the date of expiry of the permission to work on their profile. And it will also show the date that you've made the check. And so a PDF print of that in and of itself is sufficient. You might still want to record it in a spreadsheet if you're doing a bit of both, and we'll see later why you might need to do some checks manually and some electronically. If you want them all in one spreadsheet, then you can also put it in the spreadsheet. But because the electronic copy shows the date of check, then that's sufficient as the record of the date that you did the check for electronic checks. Okay, only for electronic checks can it be on this PDF. All right, so before COVID, whether you were doing it manually or checking online, you had to look at the person. You had to see them in person to make sure that it was their document. So, you know, do they look like the picture? Do they look the right age? If you are handling documents, have they been tampered with? That sort of thing. And always, you would have to recheck those with temporary permission. That's still the case. So that's a brief overview of right to work checks. If somebody has questions, I'm happy to take them, but I don't want to linger here too long because there are, frankly, more exciting things to talk about. But does anybody have a burning question about how the actual right to work checks work? No. Okay, let's move on then. So let's talk about checking documents up until 17th of May. So on 17th of May, it changes. All right. So this is through 16th of May, what we're going to talk about now. And it's a COVID-19 policy. We'll talk about how the significance for the manual checks and for the electronic checks. Okay. So there's a temporary policy in place. It's valid from 30th of March last year. And in recent weeks, the Home Office announced that it's coming to an end on the 17th of May, 2021. All right. Now, under this temporary policy, because of the dangers of transmitting COVID, you're allowed to check documents and status remotely. All right. So the way that would work is you request a scanned copy or a photo of the original document to be sent to you via email or on your mobile phone. So WhatsApp, for example. And then you arrange a video call. Okay, you schedule a video call, Zoom, etc. And you ask the owner of the document to hold it up during the video call. You check it against the scanned copy provided. And that's when you look at, you know, has the expiry date passed? Do they look like their picture? Are they the right age, seemingly, etc. Okay. And that's how you do the check. And then you note either on a printed hard copy that you have adjusted check undertaken on date due to COVID-19, and you have to write the date in there, or you can write that in your spreadsheet. All right. So that is how you can check hard copy right to work documentation manually. It's the manual check process up until 17th of May. Any questions on that? Okay. So again, you have to either print the scanned copy you have or keep a spreadsheet. If you're doing manual checks, you can't record the date on the electronic copy. So you can't just receive it in an email, save it electronically, and, you know, adjust the PDF to write this on it. It has to be on the physical copy or in the spreadsheet. Now, do not just write the date. What does that mean? In almost any type of documentation you're dealing with, if you want to authenticate it, you know, confirm that you approve, etc., you're making a contract, whatever, you would sign it and then write the date, and that would show the date that the document was signed, right? No, that's not sufficient here. You can't just write the date because the Home Office says if you just sign your name, write your name, and write the date, that doesn't actually confirm the date on which the check was made. I don't know why it's acceptable in every other legal realm and not to the Home Office, but there you have it. So if it's a check undertaken under the COVID-19 policy, you have to write adjusted check undertaken on whatever the date is due to COVID-19. And if it's not, then you have to write check undertaken on date. You can't just write the date and sign it, okay? So these are the particularities that I'm talking about, which might land you in the realm of having done partial checks and not benefiting from the statutory excuse. I see there's something in the chat. Oops, I don't know how to access the chat. Just a sec. I don't know what's happened here. There we go. Sorry about that. All right. So KM asks, what if the person has a recently expired passport, but they've already applied for a new one? Okay, so this is a general right to work checking question, but I'm happy to take it quickly. So do you need to record the specific time? Candace, no, you don't need to record the specific time. Okay, so if somebody has an expired passport, it depends on what type of passport it is. And I'm just going to save that question, actually, because it will come up in a few slides' time. So if you'll just bear with me, KM, we'll talk about that again in a minute. Okay, so let's talk about the COVID-19 policy as it affects the electronic checking process. Okay, so you remember this is one where you're able to access the person's profile, immigration status online. So this is part of the same policy that was introduced on 30th of March, 2020. And in terms of electronic checks, the way they work remotely is that the person first generates what's called a share code, okay? Now, the share code basically is a way of them granting you permission to access their online status. But not everybody can generate a share code to support an electronic check. People with biometric residence permit can, or biometric residence permit can, biometric residence card, those with status under the EU settlement scheme, apparently people with British national overseas visa, though I haven't tried that myself, a frontier worker permit, and the policy says status under the points-based immigration system. I've been trying to get the Home Office to confirm what this means exactly, but I don't have the answer yet. Hopefully I'll be able to update you all in my next newsletter. But yeah, at the moment, it's not totally clear, and we'll talk about why that's really significant. So first of all, they generate the share code, okay? They do so on one page on gov.uk, and then you access their immigration status by going to another page on gov.uk and entering their share code and their date of birth, and then you'll be able to view their online immigration status profile, okay? And that will state whether they have the right to work in the UK or not. It will state the expiry if there is one, as I said before. And what you're doing is you're having a video call. So you arrange a video call and you access their online status in real time whilst you're on the call. And then you check the profile that you see online against the person, and you print the profile page. See, there's another question in the chat. I don't know why. So sorry, I've never had this issue before. I'm trying to access the chat. Here we go, sorry. All right. Alexis asks, what if the home office website isn't working? Oh yeah, that's true. I'm sorry, there's no good answer for that. You're just going to have to wait and possibly even delay the person starting working for you if the home office website isn't working and you're dependent on the electronic checks. So it's totally erratic. I appreciate that. Welcome to my world of pain dealing with the home office technology. But yeah, you'll just have to wait till it's back up again. Usually, actually, the outages are pretty temporary. So my advice would be just to wait. So again, you're checking that it's the person and you're printing the profile and you're saving it to file. And that's enough in and of itself in terms of the date of the check because it's on the profile. But you can add it to your spreadsheet if you want to. Do we do electronic checks for settlement status of existing employees? Zella says. Okay, so I think this has to do with EEA nationals who are already your employees. We will talk about EEA nationals separately in a minute. And so what we're going to talk about is whether you should, and then the format, how you do it doesn't really matter. But we'll talk about whether you should in a minute, and I hope that will answer your questions, Ella. If not, let me know then. But there's a whole section on EEA National, so we'll talk about that in a minute. Okay. Retroactive checks. So some of you might know that when this temporary policy was introduced, the Home Office said, you can do the checks this way remotely for now, but this policy is not going to be in place forever, okay? And if you've done a remote check, then within 8 weeks of the termination of the policy, you have to redo the check. You have to do a retroactive check, okay? That's what they said when they introduced the policy. Now what they've said is that these retroactive checks are not required, okay? And they're saying this is a gesture in recognition of the administrative nightmare, their word was burden, on companies to have to redo the checks that were done under the temporary policy. And so they had said retroactive checks were required if you were using the temporary policy. They are not required, okay? So if you checked according to the temporary policy, that's fine. You only need to recheck as you always would. So if those checks were with temporary documents showing a temporary right to live and work in the UK, then you still need to recheck those, before expiry or within 6 months of the positive verification notice. But otherwise, retroactive checks are not required, okay? So what's going to happen from 17th of May, 2021 onwards? Well, manual checks are going back to the way they were before the COVID-19 policy was put into effect. So you have to view the hard copy original document. You have to meet the person in real life before they start work or start working if you're meeting them on the day. You have to make a photocopy, etc. Electronic checks can continue as per the COVID-19 policy. And this might not be forever, but for now, no termination date has been specified. Now, this really creates a divide between those who can use the electronic checks and those who can't. So, we had a look at people who can generate a share code. British nationals aren't on that list. So there are people who are going to have to come into the office. So there are some issues with the 17th of May change. First of all, the government instruction, as we understand it at the moment, is to work from home if you can until the 21st of June. So this is a classic case of the Home Office just kind of not really caring what other branches of the government are saying, and making up its own requirements that don't really necessarily comply with other government requirements. So as I said, British passport holders and basically everybody else who can't use the electronic checking system are going to have to come in person, whereas those who can don't have to come in person. So that's quite significant. And you saw that I had been drawing little squiggly lines under the item in the list of those who can use it, being people with status under the points-based immigration system. So it's really significant to know the answer to that, actually. And I really hoped that the Home Office would respond in time for this. But basically, let's say you sponsor someone, okay? Let's say it's from 1st of January. You've sponsored them after 1st of January. They're coming over and they have the temporary visa. Are you going to be able to check their right to work electronically? If not, is that going to affect the start dates? You know, they have to get here. If you can't check it on the base of their temporary vignette electronically, you know, once they have a BRP card, you can check it electronically. But if you could check it on the basis of their temporary vignette, then that would really help, because they're going to have to quarantine. I mean, even if they're not on the red list, which is the significance of which is if you spent within the 10 days before you travel to the UK, if you've spent time in a country on the red list, then you have to quarantine in a government sanctioned hotel. But even if you're not on the red list, you have to quarantine in private residence, or your own hotel accommodation of your choice, etc. So one is called managed quarantine, the government approved hotel quarantining, and one is unmanaged quarantine, if you will. But so let's say the visa holder comes in, then they have to quarantine. And so then they can't actually start work because they need to quarantine unless they can do these electronic checks. So there are a number of problems with the 17 May change, and maybe there will be some backtracking on the part of the Home Office or some clarification about sponsored workers. Let's hope so. So let's talk about some strategies. You could check before the 17th of May, 2021, if you're dealing with new hires who have British passports, right? Otherwise, you're going to have to do all of the manual checking that's described there, viewing the hard copy document, etc. So to avoid that, you could do the check before the 17th of May. Now, the publication about the change, the 17th of May change, in and of itself doesn't clarify whether it's just the check that has to be done before the 17th of May, or the person's start date also has to be before the 17th of May. But in right to work documentation and publications generally, it has to do with the start date. So even though it doesn't say it, for a belt and braces approach, if you can, I would do the check and have the start date before the 17th of May. If you're dealing with a British national or possibly a sponsored worker, and you want to do an electronic check to enable them to start working without having to meet with them in person. I hope that makes sense. I feel like I didn't present that in the clearest way. Does anybody have questions on that? 17th of May change? No? Great. All right, let's talk about European Economic Area nationals. So Zella, this is where I hope to answer your question on that, and also the question about expired passports should be answered here, but let me know if not. So, quick review of EEA nationals' right to work. And I have to say that at this point, those of you who have been attending my webinars over the past year, I would expect you to be able to recite this to me, because I feel like I've said it so many times, but I'll say it again. So there's an EU settlement scheme in place for EEA nationals and their family members who were living in the UK before the transition period ended at 11 p.m. on the 31st of December, 2020, okay? They might be eligible for pre-settled status if they haven't been in the UK for 5 years, or settled status if they have been in the UK for 5 years. And the deadline to apply is 30th of June this year. I'll just say that again. The deadline to apply is 30th of June. That is now next month. Moving on. EEA nationals could have the right to work through a frontier worker permit. It's not terribly useful, but it can be a kind of backup for those who are not eligible for the EU settlement scheme. Otherwise, they will need to have permission to live and work in the UK under one of the other routes in the immigration rules. For example, skilled worker, which used to be called Tier 2 General. Sorry, I seem to keep returning to sponsorship issues. All right, let's play Spot the Difference. So this Natasha has been living in the UK since 10 p.m. on the 31st of December, 2020. She hasn't applied for the EU settlement scheme yet. Does she have the right to work? Now, I haven't done a poll for this, but if anybody knows the answer, put it in the chat maybe. Yeah, let's see what you've got. She does, Sephora. Now, Sephora has said yes. Candace has said yes. KM has said yes. I'm proud of you guys. So she does. Now, is there an issue with this passport? Sephora, maybe, do you see an issue with this passport? Look at the details there. It's expired. That's right, Alexis. Is that an issue? That's right, Candace, it's expired. It expired on the 23rd of February, 2019. Actually, that's not an issue because British nationals' passports and EEA nationals' passports can be expired. It's fine to check an expired passport of a British or EEA national. That's not the case. So you would still, that still counts as a list A document. You would still benefit from a statutory excuse from penalty for the duration of the employment without having to recheck, even if that passport is expired, because it's an EEA passport, and the same goes for British passports. Now, what if the passport was of a non-EEA or British national and they just had indefinite leave to remain stamped into it and the passport had expired? That would not be acceptable. That would not be an acceptable right to work checking document. So it's not everybody's passport that can be expired. That's right, KM. The answer is no. Okay, very good. I'm really proud of you guys. I should have a Immigration Geek Academy. You're all members. So let's go back to Spot the Difference though. So the Natasha on the left, for me anyway, has been living in the UK since before the end of the transition period. And the one on the right arrived a few hours later on the 1st of January. Is there a difference between these two documents that might be presented to you? There's no difference between these two documents. And yet the Natasha who's been here since 10 p.m. on the 31st of December last year has the right to work in the UK, and the other Natasha does not. So is that a problem? What's your problem? What's your problem, guys? So the problem is obviously the individual doesn't have the right to work, but has documentation that's prescribed by the Home Office. But you don't know when Natasha arrived. You haven't asked her. So you're just checking the passport, and the Home Office has confirmed that checking the passport is sufficient until the 30th of June, 2021. Okay. So you can invite those with status under the EU settlement scheme to evidence that status, but you may not insist. Okay, so this goes back to the question of whether you should be checking EEA nationals electronically. The Home Office has said you can ask them to evidence their status under the EU settlement scheme, but you can't insist. And if they haven't been granted status under the scheme, then you won't be able to check them electronically. I have a question here. Candace says, cannot apply to the EU settlement scheme, but she might have a right if she's a family member of an EU national who's eligible for the scheme. I'm not sure what you mean there, Candace, but maybe we can come back to it. We're running out of time. There's one more thing that's really exciting that I want to talk about after we get through this. So that was seemingly quite a bad problem, right? You've got somebody who doesn't have the right to work, or you don't really know if they do or not, because the document could mean one or the other. Well, it's not your problem. It's not a problem, because the Home Office has confirmed that you won't be liable for civil penalty. Okay, as long as you conduct the checks as prescribed, and those documents that we looked at are sufficient. So as long as you do it as prescribed for those employed, and again, this is where the usual language comes in about the person starting employment before the relevant date. For those employed before the 30th of June and checked before their employment, you'll still benefit from the statutory excuse indefinitely, okay? And there's no requirement for retrospective checks to be undertaken on EEA nationals employed on or before 30th of June, 2021, okay? So come 1st of July, you don't have to retrospectively check the EEA nationals that you checked, say, between 1st of January and 30th of June this year. You don't have to recheck them. You will still benefit from the statutory excuse, unless you come to know that they're working illegally, or you have reasonable cause to know that they're working illegally. That is that, they arrived after the 1st of January, and so they don't have the right to work. Then you wouldn't benefit from the excuse. So, new right to work checking guidance is coming into force on the 1st of July, 2021. It hasn't been published yet, okay? So we will definitely need to revisit right to work checking after 1st of July. Now, you may undertake retrospective checks from 1st of July, but you do not have to, okay? But let's say you want to. So if you're doing that, you could request right to work documentation from those EEA nationals who've only provided documentation of their nationality, so say their passport, and you can also request it from EEA national family members who are relying on documentation under the EEA regulations. So that could be in their passport, or it might be one of those funny blue cards. If they were employed before 1st of July, 2021, you might ask them to provide their documentation, and you can insist. But if you're going to do that, make sure you give them plenty of notice, more than once, I would say, and document the policy, okay? Don't treat those with time-limited permission less favorably. So don't think, oh, well, this person only has pre-settled status, so there's no sense in getting them on the promotional career track because they won't be able to stay here. You're not supposed to take decisions on those types of bases, okay? So that's it on future and retroactive checks. Let's talk about more directly discrimination. It's a really interesting topic in terms of where it intersects with immigration law, because immigration law is inherently discriminatory. That's kind of the point of immigration law. So you get these very interesting scenarios where discrimination, employment law, and immigration law meet. So let's talk about recruitment, discrimination and recruitment. First of all, I just want to stress, I love talking about this. It's very interesting. I'm going to, give you some tips, etc., and let you know, give you the context. But this is the type of thing where you really should take advice on a case-by-case basis, because the devil is in the detail. It'll have to do with how you word things, how you're using data, why you're doing this or that. So there's always this very fine balance of immigration and employment law risk, because you can't satisfy both entirely always. So it will be, to some extent, a business decision where your risk is going to lie. But there are things you can do. So first of all, document. I know I sound like a classic lawyer saying that, but please do just document your recruitment and selection processes. Also so that, people who are involved in the process know what they're doing and have a reference, but also to show how the decision was taken. Don't prevent people from applying. So don't make blanket statements about, so-and-so need not apply. I would recommend that you leave the question of right to work until quite late in the recruitment process. But regardless of when you do it in the process, make sure you ask everybody at the same stage if you're going to ask them for right to work documentation. And consider the wording of your request. I think a lot comes down to the person's emotional reaction. So be as benign as possible as you can with that wording. So when you're making the decision, it's best if you can rely on merit as much as possible. There are obviously always other considerations. And now I want to talk about quite an interesting point that arises out of this confluence of discrimination and immigration law. It's a bit complex, and it took me a while to get my head around it. So I'm going to take it very slowly. So basically, if you are making a decision in recruitment or in relating to employment, you cannot justify a discriminatory decision on the basis of costs alone. Okay, so that means you can't say this would be too expensive for the company, and so we're making this decision even though the result is discriminatory. But you could do what's sometimes referred to as costs plus. And there was this case, the Heskett case, in the Court of Appeal. Judgment came down in November of last year, I believe. And the judge there doesn't like the term costs plus, but basically he argues that that's the appropriate, that's really the appropriate analysis, where you're taking into consideration the whole story. Thanks for the definitive language there, Judge. But anyway, basically, if you make a decision based solely on costs, avoiding increased costs, you're not protected against discrimination claim. And in the Heskett case, the point was that they had rearranged their promotional structure so that people under a certain age weren't going to be earning as much. And there was a discrimination claim brought on the basis of age discrimination, okay? Now, what's interesting in that case is that the court distinguished between a decision that was made because something cost too much versus a decision that was made because you had to stay within budget to protect the viability of the organization, to allow the organization to continue to exist. And the judge there basically thought that in the latter case, where you're acting under budget constraints, defined budget constraints, such that the organization is really at risk if you have to pay the costs of to avoid the discrimination, then that budget consideration satisfies costs plus. Okay, so staffing constraints for business viability can provide that necessary plus. Now, Heskett is a very specific case. It was actually a public body, and so it was like government budgets, etc. But it raises an interesting issue for sponsorship, and particularly now that medium skilled roles are eligible for sponsorship. So previously, I was very often asked, and I'm sorry, we're running over. If you need to leave, this is being recorded, so we can send you the link. So previously, I was very often asked, oh, look, we went through the recruitment process, and there's this sponsor, there's this person who would need to be sponsored that satisfies all the requirements. They're the best person. Do we have to hire them? And the easy answer when the resident labor market test was required was no, you don't. Under immigration law, there's no requirement to do so. And then because of the resident labor market test, that would kind of satisfy the plus element of costs plus. And so you were safe from a discrimination claim. Now there's no more resident labor market test. Well, in the vast majority of cases anyway, okay? So there's you're not getting your plus factor there. Is there an obligation to sponsor? Well, there might be if, a judge thinks that you're otherwise making the decision on the basis of costs alone. Now, particularly if you don't yet have a sponsor license, sponsorship is very expensive, okay? So you might think, well, we just, this would cost too much. We can't hire this person. There might be a discrimination claim there. And particularly because, sponsorship is now open to medium skilled roles. You could be getting, huge volumes of applications for any given role. So that could be an issue. What's the best you can do? Keep documentation of the decision-making process and keep documentation of your budget. If you're working to a budget, document how much you're allowed to spend on the recruitment and the effects, why that's relevant for the business as a whole and the viability of the business. That might be a way of overcoming of fulfilling the cost plus analysis. So I hope that made sense. As I said, it's quite a bit to get your head around, but it's a very interesting point that's developed. I'll quickly wrap up by talking about right to work and termination aptly. Where somebody can't provide the right to work, the right to work documentation, the correct right to work documentation, what should you do? Well, don't make a knee-jerk reaction, okay? You still have to follow your normal dismissal processes. Give them plenty of options, plenty of time, opportunities to provide their right to work documentation. I often get asked whether the individual should be suspended or not. Is that really the question? It's not actually, because suspension isn't going to save you from any liability under immigration requirements. Because even if they're suspended, they'll still be employed. And in terms of dismissal grounds that you might rely on, I would recommend relying on contractual grounds if you have them. So you've put in the contract that the person needs to have the right to work in the UK and that you'll be checking their documentation. If you have that, then you could also, well, regardless of whether it's in contract or not, failure to comply with a reasonable request, that is to provide the right to work documentation in line with the Home Office requirements, that could be used as a dismissal, as a grounds for dismissal. I would not rely on the ground of a duty or restriction imposed by or under an enactment. And why is that? Well, because right to work checking, according to the government requirements, is not actually a positive obligation on all employers. It only serves to afford employers the statutory excuse. Employers are required to prevent illegal working. They are required not to employ people who don't have the right to work, but the checks themselves are not a statutory obligation. So don't rely on that, and ensure that you provide the right of appeal. So that's it. I did see that there was another question, but I'm aware that we're well over time now, and I apologize for that. Oh, it's not, oh yeah. So Zella asks, can a non-UK resident make a discrimination claim? Yes. So we're getting into employment law a little bit, and I live and breathe immigration. So I'm not certain of the answer to that, but my understanding is yes. I can refer you to an employment colleague of mine for a definitive answer. And Joe says, thank you. Thank you, Joe. And thank you all for joining today. I really appreciate it. And I hope you found it as interesting as I did. I think it's a great topic. If you have any questions, my details are there. Do follow up with me. And I'll be sending out a newsletter. If you didn't get the one I sent out yesterday and you'd like to, just email me, I'll forward it to you, and you'll all get the ones going forward in any way. Thank you so much for your kind words, guys. I know I don't really get to see you, but it's nice to make contact of some sort. So thanks very much. Take care, everybody.